Good afternoon, ladies and gentlemen. Welcome to the Burke County Board of Commissioners recess meeting for Tuesday, November the 2nd, 2021 at 2 p.m. Thank you for being here. I will note, Madam Clerk, all commissioners are present, county manager, county attorney, and the clerk. I'll remind you to silence your mobile devices. If you have devices that are going to make a noise, please take care of that. If you make presentation this afternoon, please come to the podium and be sure the red light is on. Press the microphone button so that we can get a good recording of the meeting. Gentlemen, item number 2 is the approval of the agenda, and I'm going to ask that we move item 2 up, swap places with item 2 and 1. Otherwise, the agenda is as presented. I would entertain a motion.
So moved, Mr. Chairman.
Thank you, Scott. All those in favor signify by saying aye.
Aye.
Opposed, no. That's everybody. All right, we have a couple items for decision today, and the first item will be the proclamation proclaiming November 1st as Power Plant Worker Appreciation Day, and I'm happy to recognize Duke Energy Representative Mike Lale. Mike, thank you for being here.
Thank you for having me. My name is Mike Lale with Duke Energy, and I'm here to request a proclamation that proclaims November 1st as Power Plant Worker Appreciation Day.
All right, thank you. And being in the power business, I can certainly understand and appreciate all the work you guys are doing at our power plant here in Burke County. Any questions for Mike on this matter, gentlemen? Seeing here none, I will entertain a motion for this item.
So moved, Mr. Chairman.
Thank you, Wayne. This is proclamation number 202109. All those in favor signify by uplifting the hand. 5-0. Fast and easy, Mike. Thank you.
Thank you, sir.
All right. This brings us back to our item from the Western Piedmont Council of Governments, a presentation of pretrial release program, and I'll recognize Anthony Starr for that. And Anthony, please introduce your folks who will be helping you.
Thank you, Mr. Chairman, Commissioners. Thanks for the opportunity to be here. I'm Anthony Starr, the Executive Director at the Western Piedmont Council of Governments. And with me this afternoon, I have Allison Adams, our Director of Community and Regional Planning, and also Todd Justice, who is a planner for us, and our Code Enforcement Supervisor. So today, we want to take the opportunity to talk with you about the possibility and the feasibility and the need for a pretrial release program for low-risk defendants. And we're going to start out with an overview of the program, and then Senior Resident Superior Court Judge Robert Irvin and Chief District Court Judge Buford Cherry will be here as well to provide some comments. And then after we've made our presentation, the judges make their remarks, then we'll open it up for discussion and questions with you gentlemen, and see what your interest and your inclination and questions you have about it and exploring this possibility. So I would preface this conversation with the part of what is driving this conversation is some court decisions at the federal level, and Todd will get into the details of this a little bit more, but the interest in, can we set up a program that is according to Burke County's desires in the ways that we think is best for our community, instead of waiting for unfavorable conditions to be imposed upon Burke County by a federal court. In addition, this type of program it's not a new concept. It's been around for quite some time, but it has been demonstrated to not negatively affect public safety, but also reduce jail operation costs for counties. And so those are the two primary ways we're coming at it. You know, you got issues of fairness as well in the justice system. The judges can talk to that as well. So I won't get into all those details, but I will just point out, for the benefit of the public and other interested parties here, you know, the Council of Governments, we've been around since 1968. All of our commissioners, you know this. And we cover Alexander, Burke, Caldwell, and Catawba counties. and serve those. We're one of 16 regional councils of government in the state. And under state law, a council of government can exercise any authority that a county can exercise if you, as the governing board, delegate that to us. And so we're governed as a governmental agency. We're governed by a board of elected officials. Commissioner Abele serves on that board as past chair of our board, and we also have 7 appointed delegates, and so we're accountable to elected officials locally and the services that we provide to help local governments provide efficient and cost-effective services and serve as a mechanism for pooling resources amongst local governments. And we think that this particular program will help, would be best administered on a regional basis because of the size of it in terms of maximizing efficiencies, having greater capacity, and helping keep costs lower. So with that, I'm going to stop here and turn it over to Todd Justice. As I mentioned, he's one of our planners and our code enforcement supervisor. And just so you know where we're coming from, both Todd and I have law enforcement backgrounds, so we're coming at this from a public safety standpoint, but also what does good governance look like, right? And what does good administration of justice look like? And so I'm going to turn it over to Todd for him to walk you through the details. He's leading this program and the potential development of it for our county. So, Todd.
Good afternoon. My name is Todd Justice. As Anthony said, I'm a planner with the COG. I've been there for about 2 years. And I've been kind of the project manager on this initiative that we're trying to get going here in the region for the past 6 months or so. Before I get into the slides, what I'd really, I want to make a few points or point out a few things first. What we're talking about doing here is not in any way changing the way that the current bond system in North Carolina is set up. What we're actually talking about doing is providing a service. I actually help the magistrates and the judges here in the 25th Judicial District and in Burke County to have a few more options, a few more tools in their kit bag, if you will. And as Anthony went over, one of the things that we're looking for is to save the county some money in jail costs and then long-term costs for the social services that the county and the state provide due to the repercussions of incarceration that comes often with pretrial confinement when a person hasn't even been, convicted of a crime at that point. Another thing that I would like the board to keep in mind is that the state's bond policy or the bond statutes and the district's policy are focused on ensuring that a person appears in court. And that's where it begins and that's where it ends. The bond policy is not there to prevent crime. It's not there to punish someone who's committed a crime. Its sole purpose is to ensure that that person will appear on their day in court. So if you would keep that in mind as we're going through the slides here. So the state's general statute that deals with with bonds is General Statute 15A 534. And you'll see there that it lists 5 options that a magistrate or a judge are limited to when they're talking about trying to secure someone's appearance in court or ensure someone's appearance in court. If you look at the second bullet there, the statute emphasizes that options 1, 2, or 3, which are release on a written promise, which is essentially the accused signs on a sheet of paper that they're going to appear in court. Number 2, an unsecured bond, which means the magistrate or the judge places a bond on the person and they only have to pay that bond if they fail to appear in court, or supervised release. And they are required by law to consider those 3 before they go to a secured bond, which is the type of bond where they actually have to pay money in order to be released from jail prior to their court date. The last bullet there, in 2018, secure bonds, this is across the state, secure bonds were assigned in 72% of the cases. So there is a preponderance of folks who are coming before magistrates and coming before judges, having a court date set, et cetera, and then they're given a secure bond that they are required to pay a financial amount before they're able to get out of jail, so to speak. And that's what we're trying to, that 72% is what we want to try and lower across the state, actually. So here's this next slide is just a snapshot of 6 counties across the state that was taken on a single day in 2019. The light blue there, the blue lines represent the number of people that were incarcerated in those counties at the time. The light blue lines are the folks that were pre-trial. They were in jail in their respective counties and had yet to go and be tried for the crime that they were accused of. And the reason for these, there is a reason for these high numbers, and the reason for those high numbers is because essentially a magistrate and a judge have 2 options when it comes to deciding how they're going to secure someone's appearance in court. Essentially a written promise or an unsecured bond, which really doesn't put any onus on the accused, or a secure bond, which means they have to put some money forward in order to not spend the remaining time in jail. And so, giving these 2 options, the magistrate or the judge are essentially having to make a risk assessment of this individual. Do I feel like they're a good bet that I can release them now and they will show up in court 3 weeks from now or 4 weeks from now? Or are there certain factors in their particular case that make me feel that they're not going to appear in court? Majority of the cases, as they should, the magistrates and the judges are going to go on the safe side, not assume a whole lot of risk, and give that person a secure bond. And so that's why the number of secure bonds you see across the state are as high as they are. So the next slide. Basically what a pretrial release program does, and it does this through the bond policy that are set by the judges in each district. What it tries to do is lower the number of people who, or it wants to increase the number of people who have a non-financial means of securing their appearance in court. So it's not directly tied to money. Most accused low-level offenders will remain in jail at least 3 to 4 weeks. And that can have a significant impact on someone's life. If you're in jail for 4 weeks, you're not earning any money, you're not supporting your family, you're not supporting your kids, you could lose your home. These type of things have severe impacts on folks that are generally already in the lower income bracket in our society. And so it can have a very detrimental effect that has second and third order effects and repercussions throughout their lives. So the high amount of secure bonds and the high number of folks who are sitting in jails across the state has taken or is starting to take a lot of attention. The most recent high-profile case concerning this was in Alamance County, where there was a class action lawsuit filed against the county in federal court for basically the claim was, or the accusation was, that it had violated the plaintiff's 14th Amendment rights to equal protection, due process, and their 6th Amendment right to counsel. And so the county and the judges and the sheriff's office were all part of this lawsuit. And they came to an agreement with the federal court, and they signed a consent order in which they agreed to establish a presumption against secured bond for low-level misdemeanors, no secured bond for certain defendants charged with Class 3 misdemeanors, and individualized findings between the secure bond, before a secure bond was imposed. So in a nutshell, what those different categories or different changes meant was that a judge or a magistrate had to articulate why they're going to assign a secured bond, and it had to be for a fairly good reason, based on the guidance that had been put in the consent order. Next slide. So a question that we get asked a lot is, if you're not putting people in jail on secured bonds and they're being released under unsecured bonds or under supervision, will this not increase the number of folks who are out on the street committing crimes? And the UNC School of Government, which is kind of the premier organization within the state that studies criminal law and criminal justice here in the state, did a study of judicial districts 2 and 30, which already have pretrial release programs in place and do supervision, which is what we're advocating here. And they found through their study that in judicial district 2, there was actually a decrease, sometimes as high as 3 or 5%, in the number of people who, when released into supervision, committed a new crime. Judicial district 2 had a very minor 1% increase in the number of people who committed crimes once they were released into supervision. And so what can be drawn from there is that there is no, by putting more people on the street or giving more people their freedom, so to speak, they are not going to go out and commit more crimes. Another example or another question that we get often is, what about repeat offenders? Habitual offenders. For example, you've got a panhandler, down at Walmart. He gets arrested. He gets brought before a magistrate. The magistrate gives him an unsecured bond. He goes right back to panhandling down at Walmart as soon as he can hitch a ride down there. And so law enforcement are continuously having to deal with these same people over and over again. So when that individual panhandler came before the magistrate under our program, he would have been eligible for supervision. And he could have gone into our program, and there would not have been an unsecured bond or no need for a secured bond. However, once he comes back the second time, now he's in violation of a supervision, which means he already has a secured bond placed on him for the first offense when he was put into the supervision program. If he had an unsecured bond on him the first time and he comes back and he has not been tried for the first crime yet, but he's getting arrested a second time, he's not eligible for supervision. Because if you have a pending charge, then that automatically takes you out of the running for supervision. And so yes, we're talking about giving more people their freedom, giving more people the options to continue with their job, continue with their lives. But there are repercussions and there are safeties, valves, so to speak, in place that will prevent people from being able to take advantage of supervision like they do the unsecured bonds. The next few slides are brief synopsis of 4 counties that actually have supervision in place already. Buncombe County has had their system, or has had their release program for a number of years now. They do have supervision. You can see there that they have 77, almost 78% appearance rate for those in supervision and a 73% public safety rate. Public safety rate is a nice way of saying recidivism. Those folks did not, 73% of the folks that went into supervision did not commit another crime while they were in supervision. The next slide is Durham County. Durham County put $500,000 into their pretrial services program for fiscal year 19 to 20, and they estimate that they saved the county over $4 million by reducing the number of bed stays by 40,000 days that year. They had a 94% appearance rate in court, and their safety rate was at 88%. Mecklenburg County has had a pretrial services program in place for about 20 years now. For FY20, they projected they saved the county $2.6 million, and they had a 64% success rate with those in supervision. Orange County. They broke it, their stats here that shows that they broke it down by person. So the average across, and you'll see this on another slide later, the average cost to a county per person per day for a person in jail is around $100. In Orange County, they pay $1.60 a day for supervision. So that kind of gives you an idea of the savings, the cost savings that we're talking about here by putting folks in supervision rather than placing them in jail under secured bond. So the next question that we often get is, how exactly does supervision work? How do you determine who goes into supervision, and how is that process carried out? So the next few slides, I'm going to talk about that. And this is the Virginia Pretrial Risk Assessment Instrument, which is one of the first pretrial matrices that were developed and kind of serves as a gold standard for the ones that are out there now. Those 4 counties that I talked about briefly here in the state have similar matrices, have similar criteria where they try to determine the risk for putting someone in a supervision program. But let me go through this one right quick because it is a very easy example for me to explain how this works. So the first step would be when the person comes before the magistrate or the judge. And that person, the magistrate or the judge, has to determines the risk level of that person. And you can see by the chart on the right, there are various things that go into them determining what the risk level is. And these include, what is the current offense? Is it a misdemeanor? What class misdemeanor? Is it a felony? Example, etc. And then their criminal history. Do they have a history of failing to appear in court? Do they have pending charges that are still open? All these things contribute to the risk level. And then finally, what's their resident status? What's their employment status? What's their history in the community, etc. They pull all those things together on this matrix and they come up with a risk level. You can see that goes from low to average to high. The next step, that magistrate or judge will compare their risk level to what their current charge is. And so when Anthony did his introduction, he talked about, we're talking about low-level crimes when we're talking about supervision. So any crime that involves a firearm, violence, a sexual crime, any of those more serious crimes, they're not even going to be considered for supervision. But what the magistrate or judge will do at that point is cross-reference their risk level with the current offense. And the chart basically lays out what level of supervision that individual should be placed under, whether they should be placed under supervision at all. And you can see a couple examples there on the left. So someone who's an above average risk level that's charged with an offense involving a firearm or violence, like I said, is not going to be eligible at all. A low-risk level arrestee with just maybe one risk factor who's charged with such an offense would qualify for level 2 supervision. So what is level 2 supervision? If you go to the next slide. So at that point, this is when the case manager that's working for the COG and working for the county through the COG would sit down with the individual and do an assessment. The magistrate or the judge has already determined, I'm going to put this person under supervision rather than give them a secure bond. That person would sit in jail until one of our case managers come and sit down with them and do an interview and do an assessment, hopefully within 24 hours. And then we would explain to that individual and enter in a contract with them, so to speak, based on their level of supervision that's recommended by the matrix. So here you'll see that a level 2 supervision, that individual has to sit down face-to-face with their case manager every other week. And on the weeks that they're not doing that, they're required to call in and have a phone conversation with the individual, with the case manager. So what we have is a fairly frequent, constant reminder: you've got court coming up, you've got court coming up, you've got court coming up. Do not miss court. If you miss court, you're going to be arrested again. If the individual fails to do their face-to-face meeting, if they fail to do the phone conversation with the case manager, if they do anything else that violates their supervision agreement, then an order for their arrest can immediately be signed off on by a judge, and they'll be picked up and brought before the magistrate, again, this time with a secured bond placed on them that they'll have to pay in order to get out of jail. So, as we said at the beginning, what we're talking about here is trying to save the county some money from its jail costs. And you can see I think there's 9 counties there on the left that currently have supervision programs. You can see the second column shows what they pay every day for someone in jail. And then the third column is what they would pay, or what they do pay in supervision for someone who's in supervision as opposed to sitting in jail. The bottom chart on the left-hand corner, you see the little cluster of blue circles. That's the majority of the folks who are sitting in jail for a little less than a month, around 25, 30 days. And you'll see that their bonds are actually less than $5,000 or so. And so that will give you an idea of who's sitting in jail. It's the folks that are living paycheck to paycheck and can't come up with $500 to pay a bond. They can't come up with $100 to pay a bail bondsman. And that's kind of the group that we're trying to target here. If their crimes had been more serious, they would have had a much higher bond. So that tells you right there that if their bond amounts are around $1,000 to a couple $1,000s, they're probably in jail for level 3 misdemeanors. Okay. On the right-hand side, you see where we did some math there, $100 a day per inmate. The average number of days that a person sits in jail waiting for their trial is around 25. So that's $2,500 that the county is spending per head for folks waiting for their court date. We believe that a good low-level average beginning number for us to start with is around 100 clients a year in supervision. And at $2,500 a day, or $2,500 an inmate, that's $250,000 that we can be saving the county by instituting this program. The next slide just has some basic notes, some planning considerations for the program. There's just a few things I'd like to highlight here. Point number 2, the case managers would be working for the COG in Hickory, but those case managers would go out to the jails across the 3 counties that we're hoping to get this in place every day and do assessments with the defendants that have been given a supervised bond. As I said earlier, we hope to be able to do that within 24 hours. The exception would be over the weekend. Somebody might have to sit over the weekend and wait 48 to 72 hours before one of our managers can get to them. And then finally, point 6, we're looking at 3 case managers with a supervisor, 1 for each of the 3 counties, Burke, Caldwell, and Catawba, and then a supervisor who can help surge in each county if there's a large influx of cases in one county over the other. The next slide is where we break down what the actual cost of such a program we think might be. 3 case managers, a supervisor, and then the other costs that are involved in that, basically come to around $400,000 annually, and we think, or that equates to about $130,000 per county if we can get each of the 3 counties in the district involved in the program. The second option is if we can only get 2 of the 3 counties. Costs are a little less, but the actual cost per county goes up. And then the final slide is simply some links to some further information points or more data about pretrial release programs and pretrial services. So let me pause here. If you have questions about specific to the slides or what I briefed, I'll give you a chance to throw those at me. Otherwise, I'm going to turn it over to Anthony.
Questions, gentlemen?
Mr. Chairman, just for clarity, so if we get 2 counties involved, we're looking at about 120,000 savings from what you're saying, and about 100,000 if we get if we get all 3 counties, 120. If we get 2, 100,000. You're saying the max caseloads, generally what we're looking at is 100 in the service per year per county.
Right.
So, you know.
Well, so Catawba, of course, will be a little higher because their population is twice, you know, of what Berks or Caldwell's is. So they're just from a statistical standpoint, they're probably going to have more people entering the program.
Sure.
And that's why we built with the 3 case managers and the supervisors so that we can.
So the surge you're talking about, you can help out in Catawba County, which I understand that. But
Or here.
Here.
An agency, law enforcement agency might have a big surge, or it's a
Drug
big
bust,
week or something, and so you can bring staff over from the other counties, so it gives you that continuity. If you have someone on vacation, you keep things covered that way. But I would also say that we were pretty conservative on the cost savings for the counties, so your cost savings could be substantially more, but we didn't want to be too overpromise any of those, so we were trying to be pretty conservative.
were you basing those numbers on Buncombe, Orange, some of these other examples, what their caseload was, I assume? That was the assumption made.
Looking at the track
So pretty
history.
conservative, like I said, 100, that'd be 250,000 in savings.
Yes.
And then we're looking at either 130 or 150,000 in cost. So it makes,
Yes, so
it makes sense. Okay.
Yeah.
Thank you. I just want to make sure I had the numbers
Good
right.
question.
Thank you.
Mr. Chairman, several questions. You answered my first 2 during your presentation, and I appreciate that. I'm probably going to skip to the bottom and ask my most important question first, if that's all right. This looks and sounds really good. It almost sounds too good. So my question is this. I guess all of us been county commissioners for years, and you'd expect that the state convention, county commission convention would have brought this to our attention, but I've never heard of it. But my point is, why are not more counties doing it? And it sounds as good. Why is the number one reason you think that they're not participating?
Well, I think up until recently, you had 2 things that have occurred that gives you greater assurance about the success of this program. One is the Alamance case. So that's providing pressure on counties to proactively address this before a federal court comes down and imposes unfavorable conditions on you. So with the Alamance case and the other litigations going on, that's other counties now in recent years have undertaken this. So now the second part of that is you have several additional counties that have taken this on. So now you've got a good track record of how this is working out. You've had a few counties that have had this in place for multiple decades, but they were, very small number. And now in recent years, more and more counties are starting to do it, but not a majority clearly yet.
Well, and the other, I think it's a good question for me, is what happens if you do this and you have a serious crime committed during that pretrial thing? And I could mention the name, but I don't know, JR, I probably shouldn't do that, but we had a gentleman who was in jail 20 years, got out, and I think it was either 2 months or 2 years, he had murdered somebody. And where's our position as a county? Could we be sued through this system other than through the court system?
So let me say, someone that's been in jail for prison for 20 years is not the same clientele that this program is serving. Someone that's been in 20 years has served for a serious crime, right? They've been in prison for a serious crime.
Right.
These are for low-risk defendants with low-level charges that are not violent offenders. They're not charged with violent crimes. They're not been accused of rape or murder or things like that. They're not, those defendants are not going to be part of this program. So these are the lower-level defendants. So if they go and commit a serious crime, then that is going to be because it's going to be a circumstance where they didn't have a track history of that having occurred.
I understood that and read that into it, but if it did, it could. If the possibility was there, is there a difference in who is going to be held accountable for that? Or
Perhaps Judge Irvin and Judge Cherry can talk about judicial decision-making and the immunity of judicial officials better than we can, because it's actually still the judicial officials' decisions in these individual cases of whether they're on secured bond, supervision, what have you.
have we done go ahead, excuse me.
And so the policy, the bail policy that we would be operating under is written and approved by the judges. It doesn't have anything to do with the county. So there is no liability that the county is assuming here. It's all within the court system. All we're doing is providing the service of supervision to give them the option to put people in supervision, which they don't currently have.
That's what I was hoping to hear.
It's a good question.
If Burke County decides to do this and somewhere down the road we decide we don't want to do it anymore, I guess that's acceptable. You have termination agreements.
Of course.
And hopefully you'd never get to that, but just need to know if that's doable. And
Yes, just like any other contracted service you would have with the Council of Governments, there'll be termination provisions in it if you decide to go a different route down the road.
is there a projected number of how much money you would save Burke County? with this?
Just what Todd highlighted before, which was 250. You would save 200. We're projecting $250,000 a year for Burke County in jail operation cost savings.
250.
And then you add the cost of contracting with us, you're going to be well north of $100,000 in net savings each year.
Okay. One thing is an attitude question. So I think the citizens of the world, not just Burke County, are really fed up with the attitude that if people who do the crime don't pay the fines, they don't pay for the guilt or the damage they've done or none of that. Do you think this would project more of that attitude if we went to this type of program?
I don't think so. Commissioner Taylor, I think about what our founders had when they instituted our criminal justice system, the Constitution, and trials were conducted much, much sooner back then than they are today. And I don't think they envisioned a scenario where people were confined for long periods of time without having had their day in court, just because they didn't have the ability to pay a small amount of money. And so, it was days that they were tried in the early years, not what we have today in today's system. And so I think this fixes that and gets us closer to what maybe our founders envisioned with the justice system. At least that's my opinion.
Yeah.
Other questions?
Okay, so, and you can certainly ask more questions and have more discussion, but if you'd like, we can have Judges Irvin and Cherry come up and give their remarks, and at any point you're ready. So I'm sorry, Commissioner Carswell.
That's okay, Anthony. I totally agree with some of the things that you said about our forefathers and what the judicial system should have been, and it's definitely not what they envisioned. Releasing on written promises and unsecured bonds, I did see a chart on how many people were failing to appear that were released on their own personal recognizance, and the cost it cost the county to bring these people back in when they fail to appear.
The failure to appear rates went down in the second half, right?
Yes, so I can get you the data. I don't think I had them on my charts here, but the School of Government compared counties that had a supervision program and counties that did not have a supervision program. And the failure to appeal rates for those that did not have a supervision program did not increase under supervision. So the bottom line is having supervision does not increase the number of people who are failing to appear.
According to the counties being studied.
I'm trying to get in my mind what the risk reward is here. Why are we not releasing, if some of the things you said are true, you know, as a retired law enforcement officer, a misdemeanor to me, if somebody comes up and slaps me in my face, becomes a felony, okay? And I guess I'm old school thinking that people...
So the example you just gave, sir, would not qualify someone for supervision?
It would for me.
It would not.
Yeah, it would be a felony in my book. I was making an analogy there. I'm sorry, it probably wasn't a good one to you, but that's okay. If we're saying that some of those low-level crimes, why are we not using the written promise to appear more often than not? Do we have any data on that? I know they probably could. Do we have any data on that?
Data on why we are not using more written promises or unsecured bonds?
Yeah, if we're just talking about low-level misdemeanors and some of the things that would come under this new program if we adopted it, why couldn't we begin to release more people on their own personal recognizance?
You could, but the advantage of having the supervision program is you've got an intermediate step from totally unsecured and secured bonds so that there's a lower risk with the supervision that you don't have a recurrence of crime or a failure to appear.
What I'm trying to get to, Anthony, is how can I be assured that under your program that people are going to appear?
It's a risk assessment. So, and I think what we have to rely on is the track history of some of these other counties that have been doing it a while, and their data has shown good success in that respect. So relying on the criteria to assess each defendant, low-risk defendant, on their risk for showing back up for court and their risk to the community. And that track history and just being smart in the way we apply these things is the assurance that we have, I guess, in the process. But you will never eliminate risk, right? You can never eliminate that.
And there's a two-step process. So the magistrate and the judge are doing the initial assessment, and that magistrate, as we know, has maybe 5 minutes to make a decision because he's got a line out the door. And so the safety net for that is the assessment that our case manager would do the next morning when he goes in and sits down and has 15 or 20 minutes with the individual, and he can check their background history, he can check their work history, he can find out if what they're saying about where they live and how long they've lived there is true and those sorts of things. And what we've seen in these other counties is the magistrates and the judges put forward 1,000 people a year for supervision, but only about 50% of those that get actually accepted into supervision by the case managers. So initially they're being put forward for supervision, but when the guy who's actually putting his name on the paper about the supervision and has to double check all of that and make sure that the risk level is accurate, the supervision level is accurate, they're actually pushing 50% of those people back to the magistrate and saying, no, this person needs a secure bond because they're not really applicable for the supervision program. So that there's two checks there.
Okay. And the person's sitting in jail until we can see them the next day with our counselor? Okay. That's all I have for right now. Thank you.
Mr. Chairman, I had one more I didn't get asked, if I could please. If we go to this system, how does this change and what impact will it have on the defense counsel, the prosecutor, and the magistrate's office?
So we met with the district attorney Friday. And he was we've met with all the stakeholders, honestly. You folks are kind of the last ones that we've talked to here in the county. But we talked to the district attorney, and about halfway through our talk, he was like, this is what we need right now. He feels like I said before, they've got an A or a B choice, and they're often going with B because there's a little bit of too much of a risk to go with an unsecured bond, so everybody's getting slapped with a secured bond, and he realizes that, and he doesn't think that's a good thing. I don't want to put words in his mouth, but essentially those are the comments we got from it. We sat down with the chiefs of the police here in Burke County, and they had much the same questions that Mr. Taylor and Mr. Carswell have had since we've stood here. But they too recognize that something needs to change. There needs to be some sort of some other options in the system, and so I think that they, for the most part, would support at least trying out the program and seeing how it goes. There was some concern expressed on their part because due to COVID, they have seen an increase in the number of unsecured bonds that are being placed on folks right now because they're trying to keep the numbers in the jail down. Once again, supervision would provide that middle ground where we're not just going on someone's word that they're going to show up in court. They have a little string on them that we can pull back if we need to do that with supervision. Did that get to the point of your question? You wanted to know how it would affect the other stakeholders?
Yeah.
Yeah.
Basically. And the other thing, just to recap, you said that Burke County had saved $250,000, but net you'd have to deduct 132 or 150, so you're really coming up with, just so that we understand that your net gain is going to be 100,000.
Right.
And basically, is it worth that to the county to make those changes? So.
And as we said earlier, that we felt like that was a very conservative estimate on what we could save the county. We just don't know, until we were able to figure out exactly how many folks we would be able to put into supervision. But
have there been any research surveys done with these individuals, including the sheriff, to see how they felt about this program?
So the sheriff's office was in the meeting that we had with the county manager, and they brought up a case, an example of a gentleman who, if I believe correctly, was in jail he was accused of possession of stolen goods, which is a low-level misdemeanor, and he had been there for 3 months or so, 120 days, something like that. And so they pointed to him as a perfect example of someone who probably, when it comes time for his trial, if he's convicted, he probably wouldn't have gotten any jail time at all. But he's been sitting in jail for months now waiting for his trial date, which has been delayed because of COVID and all that. And so there's a fairness issue that comes up, and that they're aware of that as well.
Thank you.
Other questions?
One more comment before you go. So we're depending on one case manager to screen everybody that's arrested. Do we feel comfortable with saying, and I know you said there'd be another one, what if the other one's in another county? So, and I know we can't nail down a number of how many people we're going to see a day, but why do you feel comfortable with one case manager?
With one, well, I think what we feel like is just looking at the caseloads from the other counties and projecting that in our circumstances, we feel like that's a good start, and making sure we get the cost savings back. Sure, maybe if you added a second case manager in some counties, you would be able to process more people a little faster, but would you get the same cost savings back for those few hours or extra day or maybe just the weekend coverage? That part remains to be seen, and so just taking a conservative approach, we felt like start on a limited basis, and at some point down the road, once we've got a track history there, if we feel like there's a need and a justification for doing that, we could come back to you and say, hey, it makes sense to have an additional shared position to provide this extra coverage than starting out with one. But you don't have anything right now, So starting with one and then having the supervisor that provides the accountability and the extra coverage when the peaks and load happen or when someone's on vacation, we felt like that was the wise approach starting this off.
And the bond policy is going to stay the same with the addition of a new program here. You're asking us to pay for it. Why is it not a state program?
I can't answer that for you.
Thank you.
Other questions? Just a couple from me. Where would the ongoing counseling take place when your supervision?
The initial assessment would be at the jail. And I mean, we'd have to look at exactly the nuts and bolts of how we want to do it. But I would think that the face-to-face meetings would also occur at the jail. That way we don't have them coming down to Hickory, to our offices or whatever. We have a specific time that the case manager is going to be there at the jail. Just like if you're meeting probation or parole or something like that, you come down and meet with your case manager at that time.
We giving any thought to that, Mr. Manager? We got space for that to take place?
That would be something that would need to be explored if the board is interested in moving forward with it.
If I get a secured bond of $5,000, what do I have to come up with today to get out of jail?
So you could pay the $5,000, or you could get a bail bondsman, which I believe they're around 20% now. I could be wrong. It's been a long time since I've dealt with them. But they obviously charge a significantly smaller amount, but the thing is you don't get that money back. You're basically paying them to put forward the bond for you. So the individual doesn't get that money back, what they do with the bond.
And have you presented this to Catawba or Caldwell?
You're first.
All right, thank you.
So if you're ready, we'd like to invite Judge Irvin and Judge Terry to come up and provide their insight about the process and what their thoughts are.
Thank you all for the opportunity to speak a little bit. I guess what I want to do is back up for a minute and say, how do we do it now versus what's being proposed? The way we essentially set bonds now is based on the offense the person is charged with and a bond schedule. The reality is that's the same system we used when I started practicing law in 1985. So we are using basically a system that worked when we had no internet. So you couldn't run a record check on somebody because you didn't have a way to do it. And you didn't have big data. What you're seeing on these risk assessments is people got interested in the question of how do we figure out who's going to show up and who's not, and who's at risk of committing a crime and who's not. So what happened is people started doing research to try to answer those questions. And that data led to the creation of those risk assessment documents. And the idea is using those kind of documents as opposed to the way we've always done it helps us figure out who we should keep, who we should let out, based on some basis other than a magistrate or a judge's gut reaction to whatever information they get. So essentially, we're trying to move from a pre-1985 system to a 2020 system, 2021. And that research that you saw, that risk assessment, that's not only based on, say, the North Carolina counties, that's research all across the country, where people have looked at simply, let's go into a particular counties or cities and look, starting with what's their experience looking through existing cases of when people are charged, who commits some new crimes, who doesn't show up, and then working from that data to risk assessment tools that they then use research to validate, does this tool work? What you saw in the 2nd and the 30th district were a little bit different. Those were risk assessments created not by research, but basically getting a bunch of stakeholders together, having them come up with a system that was really less research-based and more stakeholder-based. And then folks down at the School of Government have looked at how did that system work in the first several years after it was implemented. So it's just sort of two different approaches, but the idea is the same, to try to get us to a system where we're doing a better job of attempting to assess who we ought to keep and who we ought to let out. You know, if you flip this to medicine, not many of us would be really excited about doing medicine on a pre-1985 system. That's kind of where we are. In listening to the COG's presentation to you, they were trying to project savings based on 100 cases or 100 people. That would be 2 a week. My suspicion is they're correct. They're being very conservative in their cost-saving projections if they're only assuming 2 a week. Because what you really see on a lot of these is a churn in the system, that we're processing a lot of people in, many of them who don't stay for more than a month. And the real cost to the county in terms of the jail is not the high-level offenders who are going to stay there, months or years. It's the flow of the smaller expenses. That's where the cost is. And so I'm kind of, if I had to put money down betting, I think their number's going to be, that they're going to serve and get more than 100 people out during the course of a year. In terms of, can you guarantee to me, I'm going to assure you, Commissioner Taylor, that no person will ever get out on any system and go commit a heinous crime? No. But that's true with our existing system. In some ways, a judge, from my perspective, setting bonds, there's a component of it of every time you set one, you're rolling the dice. You're trying to make a prediction based on limited information what's going to happen. I can lock everybody up, but I can assure you if that's what I do, you're going to see Sheriff Whiston over here saying, I need a new jail. And I need twice as many officers as I got. And so trying to provide perfect security, you can attempt to do that, but it's going to have a significant cost. And you're going to see it in the social services budget. You're going to see it in the people that you're detaining, you're paying child support. So what we're trying to do is get to a system that will help us do a better job predicting for the citizens who we ought to keep and who we ought to let go. But no system's going to be 100% perfect. And no judge is really excited about picking up the newspaper and seeing front page article, so-and-so judge released X who went out and killed somebody. That's not where we're trying to get, but I can't assure you that every magistrate or every judge is going to have perfect foresight and know who we get. I'm happy to guess at questions, and I'm also happy to turn it over to Burford Cherry.
Questions for Judge Urban?
Just a comment, if you don't mind, that, it's a crying shame that Eddie's belt or 2 days in jail or 10 years in jail sometimes will not change behavioral attitudes, and the guy will commit a crime a second time.
But I will tell you, I used to do a lot of criminal defense work. And I observed over time that most of my clients tended to age out. That they generally stopped somewhere in the mid-30s, that they'd either get married, have a kid, get a job, something would develop, and they tended to clean up their act. Now, I did tell David Burleson once I'd have plenty to do until the schools got a lot better. I also want to take a minute of personal privilege to thank the 5 of y'all for the support that you provided to the court system during the pandemic by making additional facilities available, for providing a whole variety of supplies, plexiglass and other things that we wouldn't have been able to effectively operate the court system without the county commissioner's support and the assistance we got from Brian Steen and the other county staff. Y'all were a lifesaver to us. Thank you.
Good afternoon. I'll do my best not to be redundant. I don't want y'all to hear the same thing 3 or 4 times. But I would like to reiterate our appreciation for what you've provided for us during the pandemic, being able to have a large space, being able to spread people out, being able to keep the business of the courts moving, which I think we've done a good job given those considerations. As to the topic today, I started practicing law in 1982, and as Judge Irvin stated, we've been doing the same thing for a long time. And what we want to try to do with these pretrial procedures is to try to take the dice rolling away as best we can. Because we as judges, magistrates, we don't have a crystal ball. And the best thing we can do is to try to find some validation tools that have been validated by data that give you a good risk assessment so that we can prevent some of these lower level folks from sitting in jail for inordinate amounts of time. Because I think we have to think in terms of, remember at what stage of the proceeding we are when these matters are taken into consideration. And that is, these folks are at that point charged with a crime. They've not been convicted of anything. And we certainly don't want bond or bail policies to be punishment, because what we find is for Class 3 defendants who are charged with an offense that carries a maximum term of imprisonment of 20 days, if you're that person sitting in jail and you've been in jail for 30 or 40 days, how much is each of those days worth when you served more than you should have served? And we do our best to avoid that now. Some of these procedures would make that even more certain. I think there would be a lot of benefit in this, in having these conversations. This is just the beginning, and it will be a long process. We've been working in Catawba County for over 2 years trying to get some of these issues resolved, and we're still in that process. And we appreciate the opportunity. I'll be glad to answer any questions you may have.
Questions for Judge Cherry? All right, thank you.
Okay, thank you.
All right, gentlemen, you've heard the information. Anthony, any closing comments?
Just to say thank you for the opportunity to come present this information. So next steps would be is if the board is inclined to proceed with this, then we'll begin working with the stakeholders to make arrangements and plans for this. It would give your county manager an opportunity to include that in the budget planning for the next fiscal year. There's a bail policy that needs to be developed by the judges and implemented on that front, and some details on setup to do this in the next fiscal year. So we're not talking about amending the current year budget in this scenario. So I just wanted to frame that up for you there. So I'll be glad to, and we're available at any point for additional conversations. So thank you.
Thank you, Anthony. All right, again, I want to thank the COG. I want to thank Judge Cherry, Judge Irvin, all the staff that's with you today. Thank you for being here and providing all this information. Gentlemen, we've heard the information. What's the pleasure of the board?
Mr. Chair, in my opinion, I'm intrigued by the program. I think we need to give it some consideration. I would be all for to defer the consideration to our budget retreat. I think it's February 5th. Madam Clerk?
I think it's the 4th.
4th, 5th, okay. But I would be willing to give it consideration, and maybe by that time, and I don't know, I should have asked this question, maybe we should, by then, we would have some feedback from the other two counties, possibly, and if they're, and showing what interest they have before, because if they have no interest, then obviously we can't shoulder the whole load, but if they do have interest, then that would tell us exactly what the cost will be, and we can budget accordingly, possibly, if everybody agrees.
Okay, I'm going to take that in the form of a motion that we defer consideration of the pretrial release program until the 2022 budget retreat. All those in favor, signify by the uplifted hand. Those opposed? None. Madam Clerk, it's 5-0. Again, thank you all for being here. Appreciate it very much. Gentlemen, any need to take a recess before we go into our Yes, I'd like to entertain a motion to adjourn this recess meeting. All those in favor say aye. Opposed, no. It's all of us, Madam Clerk. Thank you. Do we need